Hello, and welcome to today's health webinar. This episode is brought to you by our friends at Ropes and Gray. We would like to remind you that the Q&A feature is available, so feel free to send in your questions and comments throughout today's webinar. We would love to hear from you. And with that, I will turn it over to our speaker, David Pelequin.
Thank you for that introduction. I'm David Pelequin. I'm a partner at Ropes and Gray, located in our firm's Boston office, where I practice in healthcare regulatory law and also advise on data privacy issues, largely in the context of clinical research activities and other healthcare activities, advising both pharmaceutical and medical device companies that sponsor clinical trials and academic medical centers and universities that serve as sites in clinical trials, and also a large number of IT and other health data companies that are supporting clinical trials and other types of healthcare activities. The topic that I'm going to talk about today is one that I've spent an immense amount of time on over the last year and a half, and that is the DOJ's bulk data rule. I'm going to be focused in particular on implications for life sciences and healthcare companies, but the rule also has much broader implications for other parts of the economy, like financial services, online advertising, to name just a few. And as was mentioned at the top, if you have any questions, I'd be happy to answer them. If you just want to place those in the Q&A box, I will try to get to them as we move along. So just a little bit of background. I think many of you are probably have some familiarity with the bulk data rule, as I'm going to refer to it in this presentation. I think what's really important to remember is that this rule came out of an executive order that was issued not by President Trump, but by President Biden back in February of 2024. And that executive order did a number of things we'll talk about today, but it directed the United States Department of Justice, the DOJ, to issue regulations that would restrict or prohibit transactions that involve bulk sensitive personal data, and we'll talk about what that means, or United States government-related data on the one hand, and countries of concern on the other hand. Now, the thing about this rule, or this rule, is promulgated through notice and comment rulemaking and went through an advance notice of proposed rulemaking and then a notice of proposed rulemaking, all during the Biden administration. There was extensive commentary, particularly from the life sciences community on the rule, given how global life sciences are and clinical trials with sites in multiple countries and the need to share data across borders. And the final rule was published in the last days of the Biden administration on January 8th, 2025. And the rule took effect on April 8th of this year. Now, a lot of people were wondering, is President Trump going to move forward with this rule? Because as we know, he has not moved forward with a lot of Biden-era rules or has tried to roll them back. However, this is one rule, because we see this as a bipartisan issue, that the Trump administration has signaled it is moving forward with enforcement of. On April 11th, they announced extensive guidance on implementation of the rule. There was an enforcement discretion period that they announced that went through July 8th. That has now ended several months ago. And so we do expect the Trump administration to have this as an enforcement priority. And so what the final rule is doing is it's having the Department of Justice for the first time be a regulator of data transfers, international data transfers that involve U.S. persons and countries of concern or covered persons. And the countries of concern that are being focused on in this rule are the People's Republic of China, which expressly includes Hong Kong and Macau for these purposes, I think recognizing that the People's Republic of China largely controls those areas now. And also Russia, Iran, North Korea, Cuba, and Venezuela. Just to say it, given my client base, 95% of the inquiries I get about this rule focus on China because that's the major jurisdiction in which most life sciences companies are operating these days. The other ones, not so much. It's also important to remember this executive order is still out there and the Trump administration has not forgotten about it. Because the executive order also directed the Department of Defense, the Department of Health and Human Services, the Veterans Administration, and the National Science Foundation to consider issuing their own regulations, guidance, or orders that would prohibit their funds, so let's say NIH grants or DOD grants, from being used to facilitate the sharing of data and biospecimens with countries of concern. As we'll see here, the Department of Health and Human Services has separately from this DOJ rule started to issue its own guidance restricting these types of data flows. Now, I'm trying to summarize on this slide one thing about how this rule operates. And so the rule establishes two categories of what are called covered data transactions. And those covered data transactions include prohibited transactions, which essentially are transactions that would be prohibited in their entirety if the transaction were to go forward. And then a second category of transactions that would be prohibited except to the extent that they comply with certain predefined security, record keeping, and due diligence requirements. And those are called restricted transactions. And there's a few different categories of prohibited transactions and a few different categories of restricted transactions. I'm going to talk about that later in the presentation. In general, transactions need to involve, on the one hand, a U.S. person, and we'll talk about who a U.S. person is in a moment, and on the other side, a country of concern like the government of the People's Republic of China, or a covered person, which is a person or an entity that has a nexus to a country of concern. And we'll talk about the definition of those terms in a moment. The rule also imposes certain restrictions on onward transfers of data in the context of data brokerage with foreign persons. So if you're a US company and you're providing data, let's say, to a Canadian company or a French company, well, those are not going to be covered persons typically, but they're foreign persons, and the Department of Justice is concerned about a US person providing data to a foreign person that then will be passed on to a covered person. And so there's certain requirements in the rule I'll talk more about in a moment that require restrictions on foreign parties for making an onward transfer of data to a country of concern or covered person. Transactions need to involve sensitive personal data of US persons in excess of certain bulk thresholds to be picked up. That's why we call it the bulk data rule. We'll talk about what bulk means and what those categories of sensitive personal data are in a moment. And this is not a strict liability regime. Rather, the US person has to knowingly engage in the covered data transaction. But when we talk about knowingly here, you both could have actual knowledge, or you reasonably should have known that you were engaged in one of these transactions based on all of the facts and circumstances. Now, one thing I should say here that's important at the top to note is that this rule is not focused on individual privacy. That's really important to keep into mind. Even though it's talking about sensitive personal data and terminology that we often see in privacy laws like the GDPR or the CCPA, this rule is focused on national security. The statutory basis for it is IEPA, the same statute that President Trump has relied on for the tariffs. And the focus here is on countries of concern or covered persons having access to data that they can use to undermine the national security of the United States. And so that's important to keep in mind as we talk about some of the restrictions here. So the final rule, remember I said in order to be covered, you need to have a US person on the one hand and a covered person on the other hand. And also this rule only concerns itself with data of US persons. So it's important to understand who is a US person. So a U.S. person is any U.S. citizen, national, or lawful permanent resident. It also could be anybody who's admitted to the U.S. as a refugee or granted asylum in the U.S., or an entity that's been organized solely under the laws of the United States or any jurisdiction within the United States. So let's say like a Delaware incorporated corporation, or any person located in the U.S. regardless of citizenship. This last bullet is really key because it means you could have somebody who's a citizen of the People's Republic of China, but who moved to the US, let's say, to work in a lab at a university in Boston. While that person is located in the US, they're going to be treated as a US person for purposes of the rule, which can be helpful because that means that the restrictions on flows of data to covered persons wouldn't apply while the person is located in the US. However, once they leave US soil, then they're likely, if that person's a citizen of the People's Republic of China, they primarily reside there and they go back there, they're likely going to be seen as a covered person then, and the restrictions on data sharing would come into play. Now, the final rule says anybody who's not a US person is a foreign person, and that's important to keep in mind because, as we'll see on the next slide, to determine if somebody is a covered person, in many cases, they need to be a foreign person, i.e. they're not a US citizen, they're not a US permanent resident, they're not a US corporation, for example. And so, as I mentioned, the rule places restrictions on sharing of data and biospecimens with both the countries of concern, like the governments of those countries, and with covered persons. So who's a covered person? I realize there is a lot of text on the slide, and I'm not going to go through it word by word. This is going to be a good reference for you afterwards. But to break it down for you, when we're talking about corporate entities, If you look at the second part of the first bullet point, we're really focused on entities that are organized or chartered under the laws of a country of concern, or that have their principal place of business in a country of concern. So let's say we have a company that's organized under the laws of the Cayman Islands, but its principal place of business is in Hong Kong. That's going to be a covered person under the rule. In addition, for foreign entities, so for non-US entities, if they are 50% or more owned directly or indirectly by covered persons, then they are also going to be a covered person. So let's imagine that we have our Cayman Islands Corporation, and let's imagine that it's headquartered in Toronto, Canada. It's going to be a foreign person under the rule. But if it is 50% or more owned, let's say our Cayman Islands Corporation is 50% or more owned by an entity with its principal place of business in Hong Kong, that's going to be a covered person under the rule. So you really have to look at the chain of ownership here when we're talking about foreign persons to determine whether they're covered persons under the rule. When we're talking about individual people, like natural persons, if we look at our third and fourth bullets on the slide, a natural person is going to be a covered person if they are an employee or contractor of a country of concern or a covered person. So if somebody is a foreign person, let's say they are a French citizen and they are an employee of a covered person, a company with its principal place of business in Hong Kong, let's say they would be a covered person. A foreign person can also be a covered person if they primarily reside in the territorial jurisdiction of a country of concern. So let's say we have a French citizen who primarily resides in Beijing, China. That person's going to be a covered person because they primarily reside in a country of concern. The last bullet here is something we haven't seen exercised yet, but this rule gives broad authority to the U.S. Attorney General to designate certain parties as covered persons if she determines that they're likely to become owned or controlled by a country of concern or covered person, if they act or have purported to act on behalf of a country of concern or covered person, or if they've knowingly caused or directed a violation of this regulation. This last bullet is the only way that a U.S. person could become a covered person. So if somebody's a U.S. citizen or a corporation is organized under U.S. laws, it's going to be a U.S. person. Remember I said, but they could become a covered person if they are designated as such by the U.S. Attorney General. We haven't seen that happen yet. But one could imagine that, for example, the U.S. subsidiaries of Chinese entities, or those U.S. subsidiaries are organized under U.S. law, they're going to be U.S. persons under the rule. But it, of course, is possible that the Attorney General could decide to designate them as covered persons in the future. So it's something to watch out for. So the practice point here is if you're trying to determine if you're dealing with a covered person, you would compare against this AG list, but that's incomplete and it hasn't been published yet. So otherwise, you'd have to look at where people are incorporated, where their principal place of business is, and what their ownership structure is. And my understanding is a lot of the same screening tools that are used for OFAC and sanctions compliance that companies in the US have been subject to for a long time. A lot of those vendors are starting to offer services that'll help screen against whether counterparties are covered persons under this rule. Now, remember I said this is the bulk data rule. We're talking about bulk sensitive personal data. What does that mean? So transactions have to involve sensitive personal data of United States persons in excess of the bulk threshold, or the rule also applies to US government-related data, which I'll spend less time on today because it's less relevant to the life sciences sector. So remember, we're only focused about US persons data here. So if you have data of, let's say, people from Europe, that's not going to be covered by the rule because they're not US persons. Now, the types of data we're thinking about here are bulk US sensitive personal data. And that includes things like covered personal identifiers, which essentially are names and demographic information and driver's license numbers, those traditional identifiers. And you need to have 100,000 or more US persons data to be considered bulk for that category. We also have personal financial data, personal health data, geolocation data, biometric identifiers, and then this last one's very important for life sciences and healthcare, human omic data, or human biospecimens from which such omic data could be derived. Now note the bulk thresholds. It's up to 100,000 persons for the covered personal identifiers. When we're talking about health data, it's 10,000 or more US persons. But when we're talking about genomic data, it's only 100 US persons. And for other types of omic data, it's 1,000 US persons. So there's bulk thresholds. I think what's important to note here is that the rule really targets omic data and genomic data and biospecimens from which those data can be derived. They are the most restricted categories of data under this rule, and that has a huge effect on life sciences and healthcare. I'll also note for completion that the rule applies to US government-related data, and that includes certain precise geolocations that are published in the back of the rule, and those are geolocations that deal with US government facilities. And then there's also sensitive personal data, regardless of the volume that the transacting party markets as linked or linkable to current or recent former employees or contractors of the United States government. So that doesn't come up very often for my clients because most of them are not trading in US government related data, but it's important to note if you have those types of data, they're also covered by the rule. Now I note in blue here that there is no exception in this rule for anonymized, pseudonymized, de-identified, or encrypted data. Again, I repeat, no exception for anonymized, pseudonymized, de-identified, or encrypted data. And that shows, as I mentioned earlier, why this isn't really a privacy law. Because most privacy laws, even the GDPR, which is very strict, say if data are anonymized, they're not covered. And why is that? Because laws like the GDPR are focused on the privacy of the individual. And if nobody knows your identity anymore, then it's not covered under the law. But because this is a national security focused regulation, anonymized data, let's say anonymized genomic data, the rule tells us, if you read the extensive preamble, it talks about how countries of concern, particularly the People's Republic of China, might use genomic data, even in anonymized form, to undermine the national security of the US. For example, if the People's Republic of China or another one of these countries of concern knows the genetic characteristics of the US population, the theory is they could better target a bioweapon against the United States. And that's why we do not see the exceptions for anonymization and de-identification that we see in most privacy laws. The last thing I'll note here at the bottom of the slide is that to measure those bulk thresholds, we're going to be looking at the 12-month period, a rolling 12-month period of transactions between the same US person and the same covered person or country of concern. And so if you have a transaction between a US company and company A based in Hong Kong, that's a covered person, to determine whether the bulk threshold is met, you would look over a rolling 12-month period and say how much data of US persons was shared between our US company and company A in Hong Kong. Now, there is an exemption in the rule in the definition of bulk sensitive personal data for data that at the time of the transaction is lawfully available to the public from a federal, state, or local government record or in widely distributed media, such as sources that are generally available to the public through unrestricted and open access repositories. And so if the data have already been made publicly available, let's say on an online website, or let's say they're posted in a freely accessible US government database, then those data aren't going to be picked up by the rule anymore. I think the theory being, well, they're already out to the public, the covered person could download them on their own, so they shouldn't be picked up, in transactions between US parties and counterparties abroad. And so this is a helpful exemption, I think, for some of my research institution clients that make a lot of their data publicly available. But I think that one thing to note is if the public repository is itself a covered person, so let's say it's a Chinese government repository you're submitting to that will be public, those data are not public at the time of the transaction, at the time the US person is submitting to that Chinese database. And so I think that would not fall into this exemption. So you really have to look carefully at, if you're trying to rely on this exemption, to think about, well, what's actually being made publicly available? And I see there's a number of questions, but I think I'm going to hold those to the end just because there's so many of them, and we will have time to get to them, I think, at the end. Now, talking a little bit about the categories of transactions that are covered by the rule, remember I mentioned that there are prohibited transactions, meaning they can't go forward unless they qualify for an exemption. And those prohibited transactions, there's two of them. There's data brokerage transactions, and there's covered data transactions that involve access to bulk omic data or human biospecimens from which such data could be derived. And then we have restricted transactions, which are vendor agreements, employment agreements, and investment agreements. And I'm going to talk about each of these on the following slides. So when we talk about data brokerage transactions, it's important to understand the definition of data brokerage here, which differs from the definition found in the Protecting Americans' Data from Foreign Adversaries Act and other pieces of legislation that also use the term data brokerage. So when we're talking about data brokerage here, we're talking about any transaction in which we have the sale of data, the licensing of access to data, or similar commercial transactions that are not employment agreements, investment agreements, or vendor agreements. And we're talking about arrangements in which the recipient didn't collect the data directly from the individuals. And so this includes both first and third party data brokerage. Let's say you're a US life sciences company and you've collected a bunch of data in a clinical trial and you want to license those data to a third party that's a covered person. Well, you collected those data, or your clinical trial sites did, directly from the individuals, but the act of licensing them to a covered person would be considered data brokerage. And this also, when you read the rule, can apply to intra-company transactions between, let's say, a US company and its affiliate that's a covered person. So this is a really broad definition of data brokerage. And at the beginning of this rule, when it first was coming into final form, a lot of my clients, particularly pharmaceutical clients, were like, well, we don't data broker, we don't sell data. But then as we started to peel back this definition, we realized, but we're frequently licensing access to data or providing access to data as part of a commercial arrangement. And all of that would be considered data brokerage. It's also important to note, and I mentioned this earlier, that there's onward transfer limitations in the rule for transactions that involve access to foreign persons who are not covered persons. If you're giving access to a foreign person, let's say like a Canadian company, access to bulk US sensitive personal data, and the arrangement would be considered data brokerage because it's like a data license or another commercial agreement in which you're providing that access, then you as a US person are contractually obligated to restrict the foreign person from engaging in a subsequent covered data transaction involving data brokerage with a country of concern or covered person. So what the DOJ is trying to do here is they're thinking, well, it's hard for us, DOJ, to regulate foreign parties. So we're going to make US parties regulate their foreign party counterparties and contracts by including these contractual prohibitions on the onward transfer of data. Now, in order for something to be considered data brokerage or another one of these covered data transactions, it does have to be commercial in nature. And the DOJ explains in the preamble to the rule that they consider something to be commercial in nature when it involves payment or other valuable consideration. And this is construed very broadly, so could potentially include if you're giving a license to intellectual property, or if you're structuring a data set for somebody, that could all be potentially considered valuable consideration. They do give this example of what they don't consider commercial and what would not be picked up by the rule. And that would be a US person if they're sharing data, let's say with a Chinese scientist with whom the US person is drafting a paper for submission to a scientific journal. And they want to analyze and describe the findings of the research. And then under this example, the US person isn't providing or receiving any money or other valuable consideration. Here, they say because there's no money changing hands, it seems like these two scientists in the US and in the People's Republic of China are just collaborating as an academic matter. This is not picked up by the rule. But in practice, many of the arrangements I think that you would see would often have agreements between the various institutions. There's usually some type of consideration changing hands, otherwise you wouldn't have a binding contract. So in practice, I don't see this exemption coming up very often. Now, as I mentioned a moment ago, we also have restricted transactions. And restricted transactions are vendor agreements, investment agreements, and employment agreements. And the final rule prohibits US persons from engaging in these types of transactions with covered persons or countries of concern, and if the arrangement involves bulk personal data, unless you comply with certain security measures, record-keeping requirements, and due diligence requirements found in the rule. And those security measures were published by CISA on the same day as the final rule, and they're quite robust measures that are really intended to prevent the covered person from having access to the data. And so this has made it really challenging for people who are using vendors in the People's Republic of China or another country of concern, because they have to put in place all these measures to restrict the vendor from being able to access the data, which may then make it impossible or infeasible for the vendor to perform the service. So you have to think carefully about whether, putting in place all the security measures is going to make an transaction feasible. Also important to note, especially for life sciences and healthcare companies, that these transactions that would otherwise be restricted are prohibited if they involve bulk omic data or biospecimens from which such data can be derived. So something that might be considered a vendor agreement and that could move forward if you put in place the right security measures and other measures under the rule, that will become prohibited if it involves bulk omic data or biospecimens from which it can be derived. Now, vendor agreements are one type of restricted transaction. And a vendor agreement is any agreement or arrangement other than an employment agreement in which any person provides goods or services to another person in exchange for payment or other considerations. So as we would think of services arrangements, these would be vendor agreements under the rule. Employment agreements are agreements in which an individual who's acting other than as an independent contractor performs work or performs job functions directly for a person in exchange for payment or other consideration. And this notably includes employment on boards or executive committees, even if the board service is not compensated. And you might think, well, how does that square with the idea and the rule that has to be a commercial arrangement and there has to be consideration? Well, the drafters of the rule said, well, serving on the board and the experience of being on that board and the reputational credentials one gets from being on the board is itself a form of consideration. Employment agreements I actually don't see come up that often because most of my US clients don't actually have employees who are covered persons, because usually those people are employed by another covered person, like a affiliate or a subsidiary that's organized under the laws of the country of concern. And so typically you'd be looking at those arrangements as between the US company and that foreign affiliate. But I have seen this become an issue with respect to board service. Then you have to think about putting in place the security measures to restrict the board members' access to data. The type of restricted transaction I've actually spent the most time on, which is a little bit surprising to me when the rule first came out, was investment agreements. Investment agreements are agreements in which any person, and we're talking about a covered person here really, in exchange for payment or other consideration, obtains direct or indirect ownership in real estate in the US or a US legal entity. So we're focused on covered persons like Chinese companies that are investing in US entities that hold bulk sensitive personal data. Now, importantly, the definition of investment agreement excludes certain passive investments, and passive investments have to meet all three of the criteria laid out on the slide. They have to be, one, made into a publicly traded security or one of the other types of investments here. Two, they have to give the covered person less than 10% in total voting and equity interest in the US person. And they can't give the covered person rights beyond those that would reasonably be considered standard minority shareholder protections. So for example, if somebody's getting a board seat or the ability to influence governance of the US party, that wouldn't be a standard minority shareholder protection, and that would cause the agreement not to be passive anymore, not a passive investment. And so remember, what we're talking about with investment agreements and these covered data transactions is they become problematic if a covered person or country of concern is getting access to bulk sensitive data of US persons. And you might think, well, we get a non-passive investment from China. Let's say a Chinese company owns 11% of the US company. It doesn't necessarily follow that they're going to get access to all the data, right? Well, when you read the examples in the rule, they actually take the idea of access and construe it extremely broadly, basically imputing access to data to the non-passive covered person investor. And so in the example here, they give this example of a foreign technology company. This comes straight from the rule that's subject to the jurisdiction of a country of concern, and it's a covered person. It enters a shareholders agreement with a US business that develops these mobile games and social media apps. They have a minority stake in the business and its investment agreement. And the investment agreement explicitly gives the foreign technology company with access to the data. So this becomes a restricted transaction. Okay, that kind of makes sense. The investment agreement says for an investor, you're going to have access to the data. But then look at what I've highlighted in bold in this yellow section here. The rule says that this would also be a restricted transaction if the investment agreement either does not explicitly give the foreign technology company the right to access the data or explicitly forbids that access. And if you go on to look at the rest of this, they're saying because it's not a passive investment, then we're assuming that regardless of what's in the contract, the investment agreement might say, hey, this foreign investor can never have access to the data. They assume that because of its control over the company, the non-passive investor will be able to get access to the data, meaning that the non-passive investor is deemed to have access to all of the US company's bulk sensitive personal data, which will make this a restricted transaction if the US company has bulk US sensitive personal data, meaning that you have to put in place all the security measures and other measures to prevent access by that investor. But particularly relevant for life sciences companies, remember what I mentioned earlier, that a restricted transaction can become prohibited when it involves bulk omic data or biospecimens from which such data can be derived. And so if we have an investment agreement in a US company that holds bulk omic data or biospecimens from which that data can be derived of US persons, that's going to become a prohibited transaction under the rule. And so when you take this in full, it seems that one goal of the rule really is to diminish covered person investment in US companies that hold bulk omic data or biospecimens from which it can be derived. And here I just state the prohibition again, that US persons are prohibited from knowingly engaging in covered data transactions with covered persons that involve bulk US sensitive personal data consisting of bulk omic data or human biospecimens from which bulk human omic data could be derived. And this will apply, the prohibition applies even if we're talking about an investment agreement or a vendor agreement that would otherwise be a restricted transaction. There is a narrow exception here for biospecimens that are intended by the recipient to be used solely for use in diagnosing, treating, or preventing a disease or medical condition. So if you needed to have a specimen sent to China, let's say, because there's a clinical lab there that does a test that's not available outside of China, that perhaps could fall into this exception, but that's a very narrow exemption in the rule. Now, I'm going to talk about some exemptions here. There are 11 exemptions in the rule, and essentially the purpose of the exemptions is to say, hey, if there's a transaction that otherwise would be prohibited or restricted, it becomes exempt from most of the requirements of the rule if it fits into one of these exemption categories. I've highlighted the 4 that are most relevant to life sciences companies. There's one for the official business of the US government that applies to federally funded activities. We'll talk about that in a moment. An exemption for corporate group transactions. It's about intra-group sharing of data. An exemption for drug, biological product, and medical device authorizations, and also an exemption for other clinical investigations and post-marketing surveillance data. I want to briefly note, though, that number 8 in this list, investment agreements subject to a CFIUS action. You know, I've recently had clients start to focus on this one because of what I just mentioned on the prior slide, that if you have an investment agreement by a Chinese party, a covered person in a US entity with bulk omic data or biospecimens from which the omic data can be derived, that's going to be a prohibited transaction under the rule. And in many cases, the only exemption that might apply there is if you go to CFIUS, the Committee on Foreign Investment in the US, and seek what's called a CFIUS action, in which CFIUS would essentially allow the transaction to move forward, but impose mitigation requirements on the company. You know, that's something that I think we're going to see more of going forward as potentially the only practical way for covered persons to invest in US entities that have bulk sensitive personal data. And I'll note that this is a reason that I've mentioned to clients working on this rule. You really need to, because of the national security focus here, get to know colleagues in your organization that work on OFAC and sanctions and CFIUS issues, Traditionally, people who worked on data privacy did not have much to do with that. It wasn't relevant to them. But it's very relevant now because this rule borrows a lot of concepts from the export control and the trade sanctions world, including this concept of, CFIUS actions here. So this is definitely a time to be collaborating with colleagues who maybe historically you haven't had reason to work with. So if we go to our next slide, the first exemption I'm going to talk about is that for official business of the US government, and this is talking about transactions to the extent that they're conducting pursuant to a grant, contract, or other agreement with the US federal government and agencies, even if the transactions also might involve partial federal funding and partial private funding. And so the relevant federal government award, let's say like an NIH grant, needs to actually direct or authorize the covered data transaction in order for it to be exempt. So if we look at this example here, let's say a US hospital receives a federal grant to conduct human genomic research on US persons. And as part of the federally funded genomic research, they contract with a foreign laboratory that's a covered person, hire a researcher that's a covered person, and give the laboratory and researcher access to the human biospecimens and human genomic data in bulk. The contract with the foreign laboratory and the employment of the researcher are exempt transactions, and that's because they're contemplated by the federal grant here, so they fall in this exemption. However, note that they would be prohibited if they were not part of the federally funded research. And you might think, why is there this exemption for these federally funded activities? Well, that goes back to the executive order that President Biden issued. Because remember, I said that executive order called upon other federal departments and agencies that fund certain activities to, in their funding awards or in their own rulemaking and guidance, to restrict transactions with covered persons. So the idea here is to avoid duplicative regulation so that if the DOJ rule is exempted, then one would be subject to whatever other conditions are put in place by the funding agency. And we've started to see very recently the Trump administration rely on that executive order to issue additional policies restricting the sharing of biospecimens with countries of concern. And so we have, effective October 24th of this year, a policy issued by the National Institutes of Health that prohibits the sharing of all biospecimens of US persons collected, obtained, stored, used, or distributed using any ongoing or new NIH funds with institutions or parties in countries of concern. And this doesn't require a bulk threshold. If there's only one biospecimen, it would be prohibited if it's NIH funded in the collection or storage of that biospecimen. There's 3 narrow exceptions here that are different than the exemptions of the DOJ bulk data rule, and require getting consent of the individual in most cases and having documentation on hand to show to NIH. And so this is really important to consider if you're, let's say, a hospital that has biospecimens that have been collected or that are stored using NIH funding, or if you're a life sciences company that might be getting specimens that were collected originally or stored using such funding. Now, there's also an exemption for what are called corporate group transactions. These are transactions between a US person and its subsidiary or affiliate located in a country of concern. And they have to be ordinarily incident to and part of administrative or ancillary business operations. So let's say that you're a US company and you have a subsidiary in Russia. You can share bulk sensitive personal data of your US persons with that Russian subsidiary if you're sharing for certain purposes like human resources or payroll or paying taxes. There's 10 different examples that are given in the rule of what would fit within this. However, the rule makes really clear that this does not cover like core business activities. So for example, research and development activities would not fit within this corporate group transaction. You wouldn't be able to share bulk sensitive personal data with the Russian affiliate or Russian subsidiary for employees there to conduct research for you. That doesn't fit within this concept of the corporate group transaction, which is really more about things that are administrative in nature. Another exemption that is particularly relevant for life sciences companies is that for regulatory approval. And these transactions involve regulatory approval data, which is data that is pseudonymized or de-identified and is necessary to obtain or maintain regulatory authorization or approval to research or market a drug, biological product, device, or combination product. And so the rule gives a lot of examples of what would fit and what would not fit within this exemption. And so the paradigmatic example here is if you have a US pharmaceutical company and they seek to market their drug in a country of concern like China, the company is permitted to submit a marketing application to the NMPA, the Chinese regulatory authority, to obtain approval for the drug in the country of concern, provided that the data that are submitted are limited to those that are necessary to obtain or maintain regulatory authorization, and the data are de-identified or pseudonymized. The rule, though, shows that this is a pretty narrow exemption because it also talks about how, well, what if the US company, rather than submitting the data directly, wants to submit the data to a vendor in the country of concern, a covered person vendor, to then submit the data onward to NMPA. And the rule says that would only fall within the exemption if Chinese law or the law of the relevant country of concern required that an in-country vendor be used. If one is using the in-country vendor merely as a matter of convenience, then that's not going to fit within the exemption here. So you really have to drill into what's required in many cases under foreign law, because that will, tell you whether something can fit within these exemptions because it's necessary in order to obtain or maintain regulatory authorization or approval. Um, if you read the preamble to this rule, it also talks about how certain licensing arrangements in which you might have a licensing agreement between a US company that will hold most of the rights to a product, but they give the rights in China, let's say to a Chinese company. This may permit the sharing of data with the Chinese company to satisfy their regulatory obligations in China. So I advise you to read the preamble carefully if you're trying to rely on this exemption. The last exemption I'm going to talk about is that for clinical studies and post-marketing surveillance data. And this exemption does not have much discussion about it in the rule. The text says it's for activities, transactions that are ordinarily incident to and part of investigations regulated by the US FDA or clinical investigations that support applications to the US FDA for research or marketing permits for drugs, biological products, devices, combination products, or infant formula. Note that this has to be incident to and part of the clinical investigation. And a clinical investigation regulated by FDA would be a clinical trial for which we have an IND or an IDE, or that's otherwise being used to support submissions to the FDA. The exemption also applies for activities that are ordinarily incident to and part of the collection and processing of clinical care data, indicating real-world performance or safety of products, or the collection or processing of post-marketing surveillance data, if the collection of that data is necessary to support or maintain authorization by the US FDA, and the data are de-identified or pseudonymized. Now, thinking about this exemption, at first it seems like, well, this might be really broad because it's about anything in a clinical investigation that's regulated by US FDA, but it really has to be part of that investigation. So in responding to the notice of proposed rulemaking comments, DOJ rejected expanding the exemption to include transactions incidental to and in furtherance of clinical investigations or post-market activities. Rather, this has to be part of those activities. And so I think what's important to note is this will not, for example, exempt preclinical research, even if that's used to support an IND, because that's not the clinical investigation. That's done something in preparation for the clinical investigation. And all of this is tied to the definitions in the Food, Drug, and Cosmetic Act. So it's important to look at those FDA provisions specifically when you're relying on this exemption. And the DOJ also explains that they recognize that some transactions that might otherwise occur in the absence of the rule might not proceed, or might proceed only subject to the requirements of restricted transactions, but that they haven't seen evidence that covered persons possess irreplaceable expertise or capabilities, and they don't believe that the proposed change to make this a broader exemption would account for the national security concerns that arise from these types of transactions. So essentially, they're saying, certain activities aren't going to be exempt. We don't have a broad exemption for all research activities. We have a narrower exemption for clinical investigations regulated by US FDA. And DOJ saying they fully expect that certain types of preclinical research that perhaps occurred in China in the past and involved bulk US sensitive personal data may no longer move forward under this rule. Also of note, and again, citing back to that Biden era executive order, we did have a press release this summer in June from the US FDA that talked about this exemption for clinical investigations. And this press release that came out on June 18th and was also accompanied by a podcast from the FDA commissioner stated that they were worried at FDA that the clinical trial exemption were overly broad, and in particular that FDA would scrutinize gene and cell therapy trials in which any manufacturing takes place in China. And they also suggested that there needed to be more transparency in the informed consent process with respect to sharing specimens with China, at least in the context of gene therapy. I mean, the focus here, and when you listen to the podcast, it's made even more clear, was on gene therapy trials in which materials are taken in the US from US persons, shipped to China to be manufactured, and sent back to the US for infusion into US persons. But it's not beyond the pale, I think, to imagine that going forward, FDA may issue additional guidance requiring certain notifications to patients if their materials are sent to China or another country of concern, which would be similar to what we see already in Europe under GDPR, where you have to warn people if their data are going to a jurisdiction that lacks adequate privacy protections. And again, this was all citing to this executive order from President Biden, which shows again that the Trump administration is still using that executive order to issue limitations on sharing of data with countries of concern. So some things practically that I'm seeing in my practice about what are we seeing as far as recent developments. Well, so with respect to license agreements and pharmacovigilance agreements between, let's say, US manufacturers and entities in China, those are really being amended to limit the use of data by covered persons to only those activities that would fall within that exemption for regulatory approval that I talked about. And so in a PV agreement, for example, you may say, you covered person Chinese company are representing and warranting that the data that you're receiving are necessary for submission to the NMPA or another regulatory authority, and that you're only going to use the data for these purposes. We also see, for example, if the data are going to a vendor first, like an assessment under the law of the relevant country about whether that's required by law or something that's just been done as a matter of practice. We also see US clinical trial sites, so health systems, universities, amending their clinical trial agreements to address this rule. So for example, if they're dealing with a foreign person, like an EU-based pharmaceutical manufacturer, a lot of those sites are restricting in the clinical trial agreement the onward transfer of data to a country of concern or covered person. They're also putting limitations on if the sponsor is a covered person, let's say a Chinese pharmaceutical manufacturer, those sites will be putting contractual limitations on the use of data that are provided to the sponsor, to those that are purposes that are necessary and part of the clinical trial, as opposed to providing broad data rights to the sponsor, as we historically would have seen. And we also see representations and warranties that the sponsor is not a covered person if the sponsor is a US person. And notification, let's say, if the US party becomes a covered person, and the ability then of the US party to either decrease the amount of data provided or to terminate the arrangement. These are things I'm seeing right now play out in contractual amendments. I also give some examples here of licensing transactions and how this might play out in that context, which I think would be helpful for some of the attendees here. So, for example, if we have a US pharmaceutical manufacturer that I'll call USCO, which outlicenses rights to a drug under development to a Chinese-based pharmaceutical company, ChinaCo, that's going to develop and market the drug in China and Japan. In that case, the license agreement, let's say it provides ChinaCo access to US clinical trial data that consists of health and genomic data in excess of the bulk thresholds. That's going to be considered data brokerage typically, and so it would be prohibited under the rule unless it fits into an exemption. And let's say ChinaCo wants access to the US biospecimens for exploratory research. But analyzing this, for this to go forward, you'd really have to limit the use of the US clinical trial data to pseudonymized data that are necessary for ChinaCo's regulatory filings in China and Japan in order to fit within the exemption for regulatory approval data. And in your pharmacovigilance agreement, you'd want to limit use of the data to uses that are necessary to maintain regulatory authorization to research or market the product. And if you are providing ChinaCo with additional rights, like the ability to conduct additional exploratory research, that's likely going to be prohibited because that's going to be data brokerage or a transaction that involves bulk omic data or biospecimens from which it can be derived. So you need to think carefully about what rights you're granting to covered persons in these licensing agreements. A second example I wanted to mention is, like, let's say you have a US pharmaceutical manufacturer, USCO, that outlicenses rights to a product under development to a Japan-based pharmaceutical company, which I'll call JapanCo, to develop and market the product in Japan and South Korea. And if the license agreement provides Japanco access to U.S. clinical trial data that consists of health and genomic data in excess of the bulk thresholds, what would you need to consider? Well, Japanco is going to be a foreign person under the rule, but they're not a covered person in this example. So we'd want to verify that they're not on the, based on their ownership structure, that they're not 50% or more owned by a covered person and they haven't been designated as a covered person by the DOJ. And assuming that's the case, because they're a foreign person, then those onward transfer limitations I talked about earlier are going to apply, where you have to prohibit the Japan company as a foreign person from making an onward transfer of the data to a covered person. Now, with respect to enforcement here, the enforcement involves both civil and criminal penalties. The civil penalties are the greater of 368,000. I think this has been adjusted for inflation since then, or an amount that's twice the amount of the transaction. If it's a willful violation or conspiracy, you can have criminal fines of up to $1 million, or they could result in 20 years imprisonment. And of course, if there's a criminal conviction, that would result in intended consequences, like potentially not being able to participate in certain federal programs. And there's no grandfathering of ongoing contracts under the rule. So let's say you have an agreement that was signed 5 years ago and is still being performed. If that agreement requires or provides access to bulk sensitive personal data or biospecimens from which omic data can be derived in bulk, that's going to be subject to the restrictions in the rule if that's occurring after that April 8th effective date. The other thing I wanted to note, and this isn't directly life sciences focused, but remember the rule also applies to covered personal identifiers, which are things like IP addresses and advertising IDs. And we're starting to see some class actions by consumers that are being filed against advertising exchanges. There was 2 filed in September 2025, one against Index Exchange and one against Xander. And these actions were brought under the federal wiretapping statute because there's no private right of action in the DOJ bulk data rule. That can only be enforced by the government, by the DOJ. But creative plaintiffs' attorneys are now alleging that the federal wiretapping statute is violated when these advertising exchanges, Index Exchange and Xander, have intercepted data from the plaintiffs through like online tracking technologies with the intention and the purpose of disclosing it to a covered person. So in this case, Index Exchange and Xander are alleged to have disclosed data they collected online to Temu, which is a Chinese advertising agency, and is a covered person under the rule. And so the plaintiffs essentially are using the federal wiretapping statute to say that because these data were provided to Temu in violation of the bulk data rule, it's a violation of the federal wiretapping statute, which does have a private right of action. And they also assert various state common law privacy theories. And so this, I mention this because you'll want to review agency agreements you might have with your marketing agencies to make sure they're not covered persons themselves or have restrictions on their ability to share data with covered persons. And this could mirror trends we have seen in the online tracking litigation. Those of you familiar with, the OCR guidance on use of pixels and cookies on hospital websites and the intended private litigation that we've seen, where litigants are using other federal and state statutes to bring lawsuits, given the lack of a private cause of action in the underlying regulation that they're saying was violated. So this is a trend that we'll need to be watching, I think, in the coming months. And that brings me to the end of my prepared remarks. We do have a few minutes here. Like I said, there's a number of questions. So let me see if I can take some of these here. So the first question says, my understanding is it isn't just data access from within those countries of concern, but access of the US person data by people of those nationalities. Is that understanding correct? So as I mentioned, the key is whether you're giving access to data to covered persons. And so you'd have to assess whether the individual receiving access to the data is a covered person. And if they are, then yes, this rule would be implicated. And the person also notes, the questioner asks, the rule can also be complicated for expats participating in clinical trials since you would typically avoid getting to that level of PII. Or is this where the term knowingly would come into play? So I think what the questioner is positing here is like, let's say we have a US citizen who lives in Berlin and they enroll in a clinical trial in Berlin. Yes, they're technically a US person in that case. So their data would be covered under the rule potentially. However, This is, I think, as the questioner notes, where this question of knowingly comes into play. Like, we typically wouldn't know that as the sponsor of the study, what somebody's citizenship is. And I would also note that it seems unlikely when we get to the bulk threshold, just if we have a handful of expats who live abroad participating in a trial. Then we have another question that says, I think they're asking about the comment I made about a US person being located in the US, not being a covered person while they're here, being a US person. They say, assume this means a visiting scholar living in the US for a brief period to work at a lab with a current pay and affiliation with a covered entity is considered a covered person. Well, no, that's not correct. If the person is living in the US, while they are in the US, they are going to be considered a US person. But the challenge is, I think, as this questioner was alluding to, when the person goes back to the country of concern, they're going to be a covered person. And so they're not going to be able to access those data anymore that they were working on in the US if it's bulk sensitive personal data. Then there's another question that says, in understanding when a company would be considered a covered person, they would need to have total clarity of their ownership structure, is the question. And as I mentioned, yes, the DOJ expects you to do due diligence on the ownership structure of the companies that you are transacting with, and determining whether they would be a covered person under the rule. Then we have a question about, is the threshold based on a calendar year for bulk sensitive personal data? The threshold is not based on a calendar year, it's based on a rolling 12-month period. Then we have a question about the Russian national example in the rule, which talks about covered persons, includes an entity in or organized by a country of concern. I'm just reading the question here. I think this questioner can write to me afterwards because this is kind of a lengthy question to get into here. And then we have a question about how broad the definition of personal health data is, whether it would just fall under objective physiological type data or also subjective data, such as patient-reported outcomes. The definition of personal health data is tied to the definition of protected health information under HIPAA, which is basically any past any information about somebody's past, present, or future physical or mental health care or health status or the receipt of health care or payment for their health care. So it's a very broad definition and includes de-identified data. Another questioner asked whether the rule applies if a covered person has bulk access to US sensitive personal data, and the covered person has the potential to access data, but doesn't necessarily have access to the data. Again, you have to look at the type of transaction there. As I mentioned, for investment agreements, for example, the rule imputes access to the covered person investor. And so it's important to analyze what type of transaction you're looking at. And then I'll take just one more or two more questions here. There's a question about omic data asking if it's 100 or 1,000 individual people, or if a single sample could result in many data points, whether that would be enough to meet the threshold. The key is the number of US persons whose data is at issue. And so if we're talking about one sample, the one sample could generate a lot of data, but it only came from one US person. So that's only going to count once against that threshold. Now, if you had the sample with omic data and you also had, phenotypic data that were health data, then you would have, one person under the omic data category and one person under the health data category. So you have to look at those categories separately. And another question is whether a Russian or Chinese national living outside of Russia or China is still a covered person. That's going to turn on whether they're working for a covered person. If they are an employee or contractor of a covered person, regardless of where they're located, they're going to be considered a covered person. But if they're a Russian or Chinese national and they don't permanently reside in Russia or China, then they may not be a covered person. They'd be a foreign person under the rule. And the last question I will take is, if you share data with an entity and are getting something in return that's non-monetary, would this be considered a commercial transaction? Yes, it doesn't have to be monetary for something to be a commercial transaction. If something involves access to bulk sensitive personal data and you're, let's say, getting IP or you're getting structured data in return, that could be considered bulk sensitive personal data that could be considered covered by the rule. And I think given time, we will end it there. But I really appreciate everybody attending today. I appreciate the great questions. And I know we weren't able to get to all of the questions in the time that we had here, but please feel free to follow up with me afterward. And I'd be happy to discuss your questions with you. Wish everybody a good rest of the Monday. Bye-bye.
Thank you to Ropes and Gray and to everyone that joined us today. Please visit our website, HLTH.com, to catch up on all health webinars and watch the recording of today's session. Join us in Los Angeles, February 22nd to 25th for VIVE.